Hi everybody, Attorney Mark Victor here with the Attorneys for Freedom Law Firm. And today I want to tell you about the 10 things that you should expect after a shooting. Now notice I didn't say a self-defense shooting, because although you might think it's a self-defense shooting, and it may be, that's not what the police hear. What they hear is there's been a shooting. So that's the number one thing I want you to expect. Expect that the police are going to be on red alert when they show up after a shooting. So what does that mean? That means do not present as a threat, right? When the police show up, they're going to know somebody's there, somebody's got a gun, and somebody discharged a firearm, and they don't know who the good guy is and who the bad guy is, and they're going home. That's what their attitude is going to be. And I guess you should expect that, right? So what do I mean by this? Don't have your firearm in your hand after a shooting when the police arrive. This seems like common sense, right? But put the firearm somewhere far away, safe. Make it clear that you are not a threat to the police officer. Number two, expect to be interrogated. After the officers get there and they secure the scene, they're definitely going to ask you, what happened? Now, I want to distinguish different times that you might be interrogated. You could be interrogated before arrest or after arrest. If it's after arrest, then the police need to tell you about the Miranda warnings, which is going to include your right to remain silent, and anything you say will be used against you. Use that to remember the most important thing: just shut up. Now, if they're interrogating you prior to an arrest, they don't have to read you Miranda. So you're going to have to remember on your own to just shut up. Now, let me drop a little footnote in here, because a lot of other, usually non-lawyers and different organizations will advise people, erroneously in my view, to say, hey officer, I've just been involved in a self-defense shooting, or I was in fear for my life, or something like that. Don't say that. That just doesn't apply to every circumstance. And if you do say that, you've just laid down your legal theory, and we're stuck with it now, even if the facts and the evidence suggest a different defense. Better to just keep your mouth shut and don't say anything. Number three, expect to be arrested. Now look, this doesn't mean that everyone after a shooting is going to be arrested. And indeed, I've had cases where there was a shooting, the police came and they did not arrest the person at the scene. That's fine, that happens sometimes. But if you're not willing to be arrested, then the seriousness of the situation wasn't such that you should have pulled out your firearm in the first place. Don't worry about it, it's just an arrest, it's not a conviction. But have a plan. What do I mean by have a plan? You might want to think before getting arrested about things like an attorney, bond, work issues. Who's going to tell people that my work, I may not be in tomorrow? Who's going to deal with my kids? So have a sort of contact or coordination person in mind. If I ever get arrested, I will let this person know and they will take care of everything. Okay, number four, expect that you may not get to call an attorney immediately. Everybody thinks they're going to get a phone call right away. Don't worry about it. You may not, but it's really not that big of a deal. Attorneys are really, truly not first responders. In fact, if you do get a hold of an attorney, any competent attorney is going to tell you the same thing. Just shut up. That's what we're going to tell you when you make that first phone call in any event. And so, not a big deal. If you don't get to call an attorney immediately, don't panic. You'll be fine, at least on that point. I also want you to know about number five. Expect that all non-lawyer phone calls from the jail are going to be recorded. That's right. When you call your spouse or your mom or your friend, whatever you say, you should be prepared and totally comfortable with the idea that the judge and the prosecutor may very well hear what you're saying on the phone. So don't say anything you wouldn't want the judge and the prosecutor to hear. Number six, expect your home and your car are going to be searched. They may not be, but there's a real chance that if you're arrested after a shooting, there's going to be a search warrant obtained for evidence or something along the lines that a police officer might believe could be connected to the crime. You may not be searched, but don't have things in your home or your car that are private that you wouldn't want the police officers to find. Keep that in mind when you think about what you keep in your home. Number 7, you should expect an initial appearance in court. What does that mean? It means you're going to be in front of a judge after you get arrested. At some point, some states like Arizona say within 24 hours. Other places it's 48 hours. But at some point, you're going to be paraded in front of a judge. That's going to be an important hearing. That is the time that the judge is going to determine under what circumstances or conditions you can be released from jail. You should probably have in your mind after a shooting, it could very well be a high bond. So you need to prepare for that. Number 8, expect to learn something you didn't want to know anything about: mandatory minimum sentences. Mandatory minimum sentences apply to almost all serious gun crimes. These are situations where if you're convicted, the judge has to put you in prison, can't give you probation. So I want you to think about this right around the time you're thinking about pulling out your firearm, because you may be charged with something that has a mandatory minimum sentences. That's going to change the entire dynamic of the case and whether you can risk going to trial. But again, if the situation for which you're pulling your weapon out to deal with isn't serious enough to deal with mandatory minimum sentences, then don't pull out the firearm. Number 9, expect a long legal battle. These cases don't usually end very quickly. We've done lots and lots over the last 26 years of gun cases. These aren't the types of cases where prosecutors just give you the standard deal on the first hearing. These are cases where everybody is looking very, very carefully at the facts. What are the facts? And then keeping in mind that little changes in the facts can completely change the outcome of the case. What does that mean for you? It's probably a long legal battle. So be prepared for lots of stress and lots of uncertainty. Again, think about this when you're pulling out your firearm. And then number 10, expect expensive lawyer fees. These cases take a lot of time and effort, and no competent lawyer is going to quote a case on a very low fee on a gun case, especially where someone has discharged your weapon. So what do I say about this? Think about this now. You need to think about this before the shooting. Fortunately for you, at the Attorneys for Freedom law firm, we have a program called the Attorneys on Retainer program. If you're a gun owner and you're worried about being put in this kind of a situation and you live in either Arizona or Hawaii, you can sign up for the self-protection plan. What does this mean? If you use your firearm and you're in a situation that you say, hey, I acted in self-defense, even if you discharged your firearm and you killed somebody, if you're charged with one of the main crimes, I'm not going to go through all of them now, that people get charged with when they take out their firearm, and you're a member of the self-protection option plan with the Attorneys on Retainer program, you don't pay any legal fees at all. That's right. We at our firm will represent you, and you don't pay any legal fees, even all the way through a jury trial. So you don't have to worry about number 10, expensive lawyer fees. Also, if you live in another of the 34 states outside, or actually including Arizona and Hawaii, that Attorneys on Retainer is offered, you should think about the standard option. What this does is it would reduce your attorney's fees down to $175 an hour. By the way, this covers almost the entire universe of everything you need in the legal world. Everything criminal, not just self-defense cases, DUIs, thefts, domestic violence, all of that is covered. Orders of protections are covered. Almost everything in the civil world, if you get sued or somebody, you want to sue somebody else, or you have a civil rights case, all of it is either at $175 an hour or a discounted contingency fee. And that's available to people in 34 different states across the country. And if you are in Arizona and Hawaii, you can get both plans at a discount called the bundled option. Check it all out at the attorneysforfreedom.com website. Just look up at the top, click on Attorneys on Retainer, AOR program. It's listed there in red. All the details are there. You can sign up online. My name is Marc Victor. I am the owner of the Attorneys for Freedom Law Firm. I hope this video has been helpful. If you have questions, you can always get a hold of me through the Attorneys for Freedom website, or you can just email me directly at Marc, M-A-R-C, at attorneysforfreedom.com. That's attorneys, F-O-R, freedom.com. Thank you.